against violence too. We would take calm and passionate without violence.
Violence Against Women's Act. Thank you, Pat. So again, thank you for joining us. We are giving it just a couple of minutes for folks to join. We've got about 34 people. So let's just give it about 1 more minute, and then Pat, we can go ahead and get started.
Sounds good.
Awesome. Okay, so I think we're good to go. So good morning, everyone. Once again, good morning to all of our COC partners and participants. Once again, we'd like to welcome you to our second webinar of the year. And so, as Emma mentioned, today's webinar will focus on the Violence Against Women Act and the HUD guidance from the years 2023 to 2024. And so, just to provide some context on that, so HUD requires that COC-funded projects comply with the Violence Against Women Act protections, particularly to protect survivors of interpersonal violence from being denied housing or eviction because of their experience as survivors. And so therefore, to ensure compliance, it is essential for all the COCs across the nation to adopt this training as part of the onboarding process for providers. And so I'm going to go ahead and get on to the next slide here. So just a few housekeeping rules. So we just want to make sure that that you please keep your microphone muted at all times unless you're speaking, just to avoid any background noise. And then feel free to also use the chat box or the raise hand function if you have any questions or comments. I have added a Q&A chat box onto our Teams, so feel free to drop your questions in that chat box. And then for a general chat box, feel free to sign in by typing your full name, title, and organization. Lastly, the facilitator will answer all questions at the end of the presentation. And so for today's agenda, we're starting off with some welcomes and introductions, and then we'll go into the Violence Against Women Act presentation that will be facilitated by Pat Leslie, who is with Urban Initiatives today. And lastly, once again, please feel free to type in your questions in the chat box, and we will answer as many as possible at the end of the webinar. And so we also want to remind you that these webinars are recorded, and that after the live webinar has taken place, the recording will be added to our website, which is located on that slide, as you can see there. And so with that, I'm just happy to turn this over to our facilitator for today, Pat Leslie, who is a consultant for Urban Initiatives. So Pat Leslie has her MSW from the School of Social Service Administration at the University of Chicago and a PhD from Loma Linda University. But more importantly, Pat has been involved in issues of homelessness as a direct service provider, a professor, and consultant, even before HUD founded the COC. So with that, I will now go ahead and turn it on over to Pat Leslie. Take it away, Pat.
Thanks, and thanks for the invitation to join you all today. In terms of a little bit more introduction for me as well, is that just know that I'm a policy wonk. I have been involved in direct services at various levels through various kinds of organizations, but my heart and soul became related to policy because of its impact on so many programs and so many people just by the stroke of a pen. So you may discover that part of this today is focused on, or you will discover that part of this today, is mainly focused on the regulations and compliance issues related to VAWA. And it may not seem very exciting or very jazzy, but very important to the daily operations and activities and compliance for HUD programs. So next slide, please. So just to acknowledge, the information in today's presentation comes from lots of resources. Next slide, please. Although the presentation doesn't contain any explicit images or language, like there's no photos or anything that would be particularly disturbing. But we know that content about domestic violence, sexual assault, stalking, or other forms of gender-based aggression doesn't need to be explicit to be uncomfortable, right? And so please feel free to take breaks as appropriate to ensure that you're able to feel comforted and that you're emotionally strong. Next slide, please. Today, there are 4 main areas that we'll be looking at: the history of VAWA itself, VAWA terms and HUD programs, who's protected, who is covered and what those protections are, and compliance and implementation, including a little bit of beyond regulations into best practices and tips. Next slide, please. So let's start with a brief history of VAWA. So VAWA comes from a 1990 public concern about the level of violence against women, particularly women who were appearing in hospital emergency rooms with lots of medical issues that were related to assault, right? And as that moved forward, it was looked at as an issue of crime control and law enforcement, not an issue of human rights protection at that point, right? It was assigned to the Department of Justice and Health and Human Services to ensure then civil rights, so moved it into that civil rights area and began to address both gender and hate concerns. And then there are several reauthorizations that you see there. You'll see that the 2020 is skipped because some parts of the 2020 were redacted, and we'll take a look at that a little bit later. But in 2013, there were broadened definitions that expanded the types of crime and then explicitly included Native Americans under the protection. And it no longer needed to be perpetrated by a spouse. And it then expanded to include both felony and misdemeanor crimes. And in 2013 as well, in March, the adoption of the Reauthorization Act brought housing protections, even though HUD didn't make a rule at that point. So housing protections were in place even before the HUD rules began. Next slide, please. And then in 2016, we begin to see that HUD implemented VAWA final rules, right? Particularly for rapid rehousing, permanent supportive housing, transitional housing, and at that point, some preventative services. And that the 2016 rule that went into effect, that was adopted as of December 1, needed to be complied by December 16th of that same year. So the expectation was that housing protections that were put into place in 2013 were being followed, and the HUD rule, final rule, simply enforced them in December of 2016. And then in 2017, HUD published additional guidance providing that the COC written standards required an emergency transfer plan, that we're going to talk a little bit more about that. And then, as we noted, that in 2020, HUD provided some additional guidance, part of which was later redacted. Next slide, please. So in 2022, from 2022 to 2024, this is the focus of today's training, right? And in 2022, there was a major reauthorization that expanded the definitions to include both technological and economic abuse, included revised provisions for protections within tribal lands, because there was an issue of enforcing violence that occurred on tribal lands that was outside of the enforcement area for anything other than the tribal leaders. And so there was an expansion and a recognition that, let's say someone followed or stalked someone onto tribal lands and perpetrated an offense there, is that now they could be prosecuted from outside as well as inside the tribe. And then in 2023, HUD released guidance for implementing the 2022 VAWA and expanded eligibility in terms of change the eligibility for definition 4 um, of the COC regulations and establish a dedicated VAWA website. I will make a note right now, because you'll also see references to that website later, is that some portions of the website are currently not interactive. We believe because of the current executive orders that are in abeyance or being implemented. So next slide, please. And then in terms of VAWA history and HUD implementation, these are the key dates and actions, which does not include the 2025 as yet, because we're not sure about the final implications. But in 2016, we've already noted that HUD implemented its final rule. And then in 2017, it published additional guidance that required the emergency transfer plan. Again, in December of 2016, the HUD program specifically needed to comply, the housing program specifically needed to comply with new guidance. 2020, we've already noted, and then 2023, the reauthorization expanded the definitions and HUD compliance rules, which we're going to see extensively. Next slide, please. So then what programs is VAWA applicable to in terms of HUD? So you see a list here. It's only a portion of the list. VAWA is applicable to all of those programs. And next slide, please. As well as this slide that's formatted differently, because these are the programs that you are more likely to be aware of. So Continuum of Care Program, Emergency Solutions Grant ESG, Home Investment, HOPWA, Section 236 Multifamily Assistance, Housing Trust Fund, Rental Assistance, mostly family rental assistance, and low income tax housing and tax credit housing. Next slide, please. So we're going to take a look at the VAWA terms, which this may seem a little dry, but it becomes important to understanding what we're needing to comply with. Next slide, please. So first, the term domestic violence in VAWA concepts does include both felony and misdemeanor crimes, is an event that is by a current or former spouse or intimate partner, and we're going to see that for HUD, it also includes a person that is situated as an intimate partner, includes the use of attempted use of physical abuse, sexual abuse, particularly when addressing victim services, or has a pattern of coercive behavior that is committed or enabled violence, right? Or situated to gain power and control over a victim. So even if it's not a physical act, if it's situated to maintain control over a victim, and you've probably seen the power and control wheel, right? It's that kind of impetus that we're going to talk about. It now includes verbal, psychological, economic, or technical abuse that may or may not be constitute a crime, right? By a person who meets certain conditions, as we're going to see on the next slide, please. So it is by a person who, and this is where we're going to see some changes, right, is a current or former spouse or intimate partner or the victim, or a person who is similarly situated as a spouse to the victim, or is cohabitating or has cohabitated with the victim as a spouse or an intimate partner, or shares a child in common with the victim, or commits acts against a youth or adult victim who's protected under family or domestic violence laws of the jurisdiction. So think about this as being vulnerable persons. Next slide, please. Look, back up one more slide, sorry. We should talk about, nope, we're gonna talk about it in the next one, sorry. Go ahead to the dating slide. So the term dating violence includes violence committed by a person who, again, has been in a social relationship of a romantic or intimate nature with the victim. Notice that's slightly different than the one we saw for domestic violence, right? Where the existence of a relationship will be determined on a consideration of but several factors. One being the length of the relationship, second being the type of relationship, and third being the frequency of interaction of persons involved in the relationship. So what does this mean? This means, for example, that if you encounter a one-night stand, right, that turned violent or coercive, right, is that relationship would not be considered dating violence because, under the domestic violence rule, because it doesn't meet all of these conditions. It still might be a crime, but it wouldn't be considered dating violence or domestic violence because of the short-term nature and and nature of the relationship. Next slide, please. So the term also, the law also includes sexual assault or stalking. And sexual assault is any non-consensual sexual activity prescribed by federal, tribal, or state law, including when the victim lacks the capacity to consent. Again, are vulnerable persons. Stalking means an engagement in a course of conduct directed to a specific person that would cause a reasonable person to fear for his or his safety or the safety of others, or to suffer substantial emotional distress. Next slide, please. So in context of domestic violence, dating violence, and abuse in later life, which is a particular focus in terms of economic abuse, these are behaviors that are coercive, deceptive, unreasonably control or restrains the ability of a person to acquire, use, or maintain economic resources to which they are entitled, and includes fraud, manipulation, or to achieve undue influence over someone's finances. Next slide, please. Right. These behaviors merely need to intend or attempt to restrict the person's access to their money, their assets, their credit, or financial information, or unfairly use the person's economic resources, including money, assets, credit, for one's own advantage, for the person whose finances they are not, or to exert undue influence over a person's finances and economic behaviors or decisions, including forcing default on a joint or other financial obligations, exploiting powers of attorney, guardianship, or conservatorship, or failing or neglecting to act in the best interests of a person to whom you have fiduciary duty. So you may have legal fiduciary responsibility for someone, but if you don't act in their best behalf, then that is also economic abuse. Next slide, please. So we've also added technological abuse, and technological abuse is a new feature in the 2022 reauthorization, where it is an act or a pattern of behavior within domestic violence, sexual assault, dating, or stalking that, again, is intended, doesn't have to actually result in, but is intended to harm, threaten, intimidate, control, stalk, harass, impersonate, exploit, extort, or monitor, except where it's otherwise permitted by law, another person using any form of technology. And those forms of technology are those that even emerging forms, right, of technology. So it's covered in that way so that rather than having a very specific type of technology list, it covers things like cell phones and all of the social media, because technology moves so quickly that sometimes we wouldn't be able to keep up with the law to protect everyone. Next slide, please. So, sorry, go back one. I should have at least done this a little bit. It does include computers, mobile devices, cameras, imaging, tracking devices, which tend to be pretty popular in terms of abuse and control currently, communication technology, or any emerging technology. Thank you. Next slide. So covered housing provider. In the Act, it says that certain persons, certain entities must help implement the law. And these are covered housing providers. And you'll see this referred to in the HUD rules as well. A covered housing provider is an individual or an entity that manages a housing program and ensures that it complies with the Violence Against Women Act. And these are programs that are supported by or operated through federal resources. And in this case, we're talking about HUD. So who can be a covered housing provider? Public housing agencies, PHAs, state or local governments, nonprofits and for-profit organizations, project sponsors, housing managers, housing owners, and mortgagors, depending upon who is helping to finance and who's occupying their units. Next slide, please. So just who is protected and what are their protections? Next slide. So who is protected? VAWA housing protections in part are available to someone who is previously or currently experiencing domestic violence, sexual assault, daily violence, or stalking. This is one area where the HUD regulations have expanded its definitions, which we'll see in a few minutes. So it's no longer just a partner. It's no longer just within the last 6 months. It's more expansive, right? The survivor does not have to be married to, related to, or living with a perpetrator to be protected by VAWA. It does not matter how long ago the survivor experienced that violence. There are some caveats in terms of being able to report violence under the Fair Housing Act. A survivor's immigration status in itself does not impact the survivor's rights to VAWA protections. And in fact, there are some equal access regulations that help support persons with alternate immigration based on their immigration status. And we will again see in 2025 what occurs with those. Next slide, please. So who else is covered? Is applied to a survivor if they are applying for, living in shelter, transitional housing, or permanent housing of any kind. So that's permanent supportive housing, rapid rehousing, other permanent housing that is subsidized by a federal homeless assistance program or other federal housing, affordable housing programs. VAWA protects survivors regardless of their sex, gender identity, sexual orientation, and regardless of the sex, gender identity, or sexual orientation of the persons who caused harm. Again, we may see some alterations in the HUD regulations in the near future. What are those protections then? Next slide, please. We're going to first identify 12 particular protections. So under VAWA, someone who has experienced violence or abuse, as we've just described, cannot be denied admission to or assistance under HUD subsidized or assisted units or a program because of the violence committed against them, right? They cannot be evicted from HUD subsidized units or have their assistance terminated for reasons related to violence against them, violence or abuse against them. They can't be denied admission, evicted, or have their assistance terminated related to violence or reasons related to VAWA violence and abuse, such as an eviction record, a criminal history, or a bad credit history. And we're going to see later on that you can't even assess if you feel that this person is credible. Right. Next slide, please. They must have the opportunity to stay in their HUD-assisted housing, even if there has been criminal activity directly related to VAWA. When there has been criminal activity directly related to VAWA. This is tricky because we may have perpetrators in the units as well, right? And they can request an emergency transfer from the housing provider for safety reasons related to VAWA, and must be allowed to move with continued assistance, even if the survivor has, for example, a Section 8 voucher, and they are going to be given priority. Next slide, please. They must be allowed to self-certify their status using a particular HUD form that was updated in 2020 and was being updated in 2023-24. It currently was not searchable on the website as of last week. Cannot be required to provide more proof than their self-certification unless the provider has conflicting information about the violence or abuse. So for example, if they say, I was violated in my unit, so I'm not feeling safe. And that was like at 7 p.m. on Saturday. And you have evidence that at 7 p.m. on Saturday, that person was actually in a self-help group in your organization. That might be conflicting information worthy of asking for additional information, right? Um, and they have a right to strict confidentiality regarding the information and their status, their violent status. And in fact, in California, there's even a higher level of protection for that. They must be given notice of VAWA housing rights, 2 forms that you see there, from a housing provider, and this must occur each time they are denied admission to housing, or they are admitted to housing, when they receive a notice of eviction, or they are notice of termination from a program. And they receive the notice each time, not just one time. You can't say, oh, well, when you came in, we gave you this notice and therefore it still applies. Each time those events occur, they must be provided those notices. Next slide, please. They are allowed to request a lease bifurcation from the owner or landlord to remove a perpetrator from the unit, right? And if the housing provider bifurcates, then it must be done consistent with applicable law, federal and state law, right? So some protections there. Cannot be coerced or intimidated or threatened or retaliated against because they are seeking to exercise their VAWA protections. It's like, I want to move again. I'm going to file a complaint. They can't be coerced or threatened. Well, if you do that, you're going to have to leave the program. They are protected against being coerced or intimidated or threatened or retaliated against, not only by a perpetrator, but by a service provider, right? They have a right to seek law enforcement or emergency assistance for themselves or others without being penalized by local law or policies because of these requests. So, for example, you can't say, well, you've already requested a emergency transfer once before, therefore you are going to stop your assistance. That would not be allowed. So compliance process review was instituted, right? So VAWA 22 requires HUD and other covered agencies to establish compliance reviews, incorporating process into existing rules whenever possible, and enumerate 6 items for compliance review required by HUD. Next slide, please. And these review include appropriate stakeholders who were to implement the changes related to the compliance review no later than March 15th of last year. So we should all be a year into our compliance review and making sure that our policies are effective, right? These regulations must define the standards of compliance under the HUD covered programs, right? Including reporting on emergency transfers, as well as standards and corrective actions where you discover that the regulations or standards have not been met. Next slide, please. So the 6 items for compliance review, you can see listed there, and they're going to sound very familiar, right? Because these are related to the protections that we've already seen. So compliance with the requirement for prohibiting the denial of assistance, compliance with confidentiality, compliance with notification, compliance with provision of accepting documentation for their status, compliance with emergency transfer requirements, and compliance with the prohibition against retaliation. Those should sound very familiar to our last few slides. Next slide, please. So let's talk a little bit about the emergency transfer plan requirement. HUD requires, and this may seem really familiar to you, HUD requires that an emergency transfer plan in each COC is part of the written standards, right? And it's clearly accessible, right? It applies to COC and ESG programs, right? It is in the written standards, and example forms in multiple language are available through HUD websites. Note that there's a relationship between COC and ESG here that can make it challenging and important to make sure that the COC is conversing with, is consulting with the ESG entitlement areas in your communities, which is also part of the regulation for the COC in general, 24 CFR Part 578, that you consult with ESG for a number of actions. It's critically important here. Next slide, please. So ETP right basics. Each COC must have a development plan, right? That all recipients and subrecipients must adopt and follow. And so that means your organization needs to abide by the emergency transfer plan in your written standards and maintain a portion or a copy of that in your records, right? The required components for the described in the transfer plan for tenant-based rental assistance is policies for program participants who qualify must be able to move quickly with their rental assistance accompanying them, must specify what will happen with respect to the non-transferring family members. So let's say that you have a household where the primary eligibility for permanent supportive housing is with one of the adults, and that adult happens to be the perpetrator, right? When someone asks for release bifurcation, what do you think would happen, right? Is that the lease bifurcation would allow for the non-eligible partner and perhaps children to stay in that unit while the eligible permanent supportive housing participant would be moved to another unit. Now, there is a caveat on that, is that if the person who is being moved from the unit is the person who carries the eligibility for that program, then the lease, the tenancy of the remaining partners in the household, so that spouse and children, only extends to the end of the lease period, whereby then you would need to find other housing opportunities, or you could allow the perpetrator who is, or you could allow the person, let me not say perpetrator, you could allow the person with the eligibility for that unit to stay in that unit and immediately look for a different type of permanent housing for that individual, for the other individuals, right? So the policies must also, the plan must also specify what will happen when they separate from program eligibility. Next slide, please. So emergency transfer plans must allow the survivor of a VAWA defined crime to transfer to a safe dwelling unit under a covered housing program if the survivor requests a transfer, even if it's verbal, and reasonably believes that they are threatened with imminent harm. They believe it. You don't have to believe it, all right? And in cases of sexual assault, if the sexual assault occurred on the premises within 90 days of the request for transfer. And then HUD has released a model transfer emergency plan to get communities started. And in fact, they updated it last year. Next slide, please. So let me make one note, which I think we come back to in a couple of slides, but in that emergency transfer plan, an emergency transfer plan request must take priority in COC and ESG placements. And that is where the relationship between COC and ESG becomes critical. Next, this slide. So new implementation requirements brought the HUD and VAWA regulations closer to the Fair Housing Act, right? And a new relationship between fair housing and VAWA. Next slide, please. So what is that relationship? So HUD will accept complaints, investigate them, and enforce VAWA using fair housing compliance processes, which are specified in those regulations that you see. And the information on the compliance process you can hook to through that website that you see. And that's new, is that being able for an agency outside of fair housing to enforce fair housing and accept fair housing complaints is an expansion. Next slide, please. So VAWA complaints do not need to allege a violation of fair housing for fair housing to accept and investigate it. So notice the crossover there is that both entities now can investigate complaints, right? And the complainant has 1 year after the violation, the alleged VAWA violation, to complain to FHEO alleging a violation. And then VAWA complaints can also be filed with FHEO, which you see listed there, or the link to the Fair Housing Equal Opportunity Office at VAWA HUD. That link that link as of last week was not fully functioning. Next slide, please. Tips and tools for HUD implementation then. So how do we handle all of this, right? HUD has provided a series of sample forms and notices in multiple language, some of which are currently being updated, and released an example of an addendum to lease agreements to ensure VAWA protections. You can see the example there, or the HUD form number there. The COC written standards need to be updated to reflect the changes in homeless category 4, which expanded conditions and changes to the description and changes to descriptions of resources. So for example, HUD description 4, eligibility homelessness description 4, expanded to include acts of violence and abuse that were not only where the person was not only fleeing acts of violence or abuse within the last 6 months, but that had been impacted by episodes of violence, including children. And so that's an extensive expansion of who can be covered under the act and who should be protected under HUD regulations, right? They ensure, you need to ensure that the VAWA rights are given at each of those times. And in fact, you may have a checklist that you provide or use your support with your staff each time one of those occurs, like what notices you're giving, to whom, in what format, who you need to notify, etc. You should review the rules to understand what happens when a household is split. And how bifurcation works. It's particularly important that persons within your agency that deal with leases, that deal with housing transfers, are aware of each of the protections. Next slide, please. And tools and tips again, you want to make sure that your agency's lease and sublease agreements incorporate the VAWA protections. Now you might say, wait, aren't we then? This is only required for persons covered under VAWA. Why would we attach it to all subleases? Why would we attach it to all leases? That would be one method of protecting the identity or the status of each individual as either being VAWA protected victim or victim of abuse or not. Is that if it's attached to all leases, then you've protected the identity or the status of an individual, as well as notified the landlord that should some perpetration occur in their units, that there's protection, right? You need to ensure that any staff that does housing navigation, negotiates lease, etc., understand those protections, and consider the flexibility in placing VAWA households outside your COC if necessary. HUD allows you to continue to support and provide a transfer of a household to another jurisdiction, and to assist impacted families with support if other kinds of entities are involved, like child welfare services or probation. Right? Next slide, please. You should visit the VAWA webpage to review the frequently asked questions. That function was still working last week. Use a checklist or a cheat sheet to guide your agency's response to concerns. And then beginning in 2023, you need to make sure that you understand that VAWA compliance and supports, right, were included as new activities in COC budgets. And there's a list of those. And if you check that you are serving persons, victims of domestic violence, HUD will automatically check one of the boxes that will allow you to use resources to help those individuals in certain conditions, with certain conditions, certain activities. Whether you have change any element of your budget or not. It did not include additional funds for your budget, right, for this purpose, but made it eligible activities. And then in every case, err on the side of safety. Next slide, please. So let's touch just briefly on the meaningful implementation, working with some other systems, maybe some best practices, talking a bit about cultural compliance and provider impact, if we might. So meaningful implementation is that it's more than following rules, right? It's not just let's check the box. It's like it's being watchful and aware, even in non-victim service provider environments. We know that VSPs are tuned into the VAWA and to protection and to confidentiality and to safety. Our other programs, however, also serve victims of violence, right? Or abuse that may not have declared or may not have claimed their status. And yet each of our environments should be aware of these protections, which is one of the reasons why HUD requires this as an annual training, right? Safety and privacy are paramount. Is that, again, err on the side of safety, and privacy is paramount. So if an individual says, this is my condition, but I don't really want you to say anything. I don't want to be moved because it will then trigger some kind of, excuse me for the language of trigger. It will then inspire the school to ask questions about my children, right? Is that you want to make sure that you're honoring the privacy concerns of your clients, right, of your participants. Empowerment and self-determination are a must, but they may not be easy. So for example, if you have someone who has had a long-term situation, environment, where their acts have been controlled, their finances have been controlled, their behaviors have been criticized or controlled over time, and they perhaps have been asked a question or asked their opinion and then suffered as a result of their response, they may not feel entitled to determine something, right? They may not, you might say, well, what would you like? We're trying to make sure we're and honoring what you want. And they might say, I don't know, or you decide, right? And those are difficult moments, is that they may not know. The interactions in their brain, which is a whole nother training, with respect to fear, may not allow them to connect to make those critical, concrete decisions, right? And so don't label that, or please avoid labeling that as non-compliance on the part of your client or as weakness on part of your client. That's exercising of self-determination needs to be nurtured. And you also want to be aware of the impact of power dynamics, even if you are kind and gentle and soft-spoken and not trying to coerce or persuade your client into doing something, right? Is that the fact that you are a person with resources, the fact that you are a person who's determining or helping to determine their access to housing and resources, the fact that you are a person who's just been privileged to know their information is a power dynamic that is almost unavoidable, but must be acknowledged in your responses and consideration and assessment of your client's behaviors. Next slide, please. So when you're working with other systems, how will that emergency transfer plan that you've written and must follow support households when they're involved in other systems like child welfare and reunification? What is your plan for that? Are you going to be an advocate with reunification and child welfare? Or are you going to make substantial agreements with those departments in advance, right? With justice and correction systems, with custody issues, for the non-perpetrator. How do you support that, right? Because the perpetrator issues are more of a legal aspect that may be outside of your realm. Mainstream assistance cases, what if they're transferring them outside of a jurisdiction? What happens then? What about, is it a question of advocacy, of education? Is it a matter of bringing in additional legal assistance? And your protocols and documentation for out of COC placements. What system, what protocols are you going to use to determine if this situation warrants an out of COC placement? And is your first action to try and negotiate with the other COC? Or is it a matter of continuing your assistance using VAWA? Next slide, please. So what about COC HUD and DV network relationships? This can be tricky, right? Because we know that COC resources do not include the COC direct resources, not ESG, but COC competitive resources do not include emergency shelter unless it's a rural provision under YHDP, under Youth Homeless Demonstration. But by and large, it does not include any forms of emergency shelter. But our COC competitive grants, which can't fund emergency shelter, may need to rely on emergency shelter and the DV emergency response networks to house someone safely and quickly, right? DV emergency shelter, DV emergency response is one primary action and service of DV networks quite often. So how do those two cooperate? When your DV transfer plan says that they must be given priority for open units and for available units within the COC and ESG programs, right? Emergency shelter programs, right? Your DV protections also include how you would use or record HMIS versus comparable databases. And there's a decision tree that we can provide. I'll send it so that it can be posted on the website as to how you know when records of an organization or a project belongs in HMIS or in the comparable database. There's a whole decision tree. Next slide, please. So practices that go beyond the minimum are VAWA program direct transfers. So your continuum in your written policies can allow direct transfers between VAWA programs for emergency transfer purposes only without using CES, right? Without going through the CES network. You could have an emergency transfer plan, central facilitator or support coordination agency or individual that helps to support all of those coordinations, which then creates efficiency and limits the exposure of the information to persons within the network, right? You could include safety planning for situations that don't qualify for DV. Maybe it doesn't qualify for a DV under VAWA, but it's still a safety issue and you want to manage that, right? You should train providers about disability considerations under DV. Right. So who's vulnerable? Special events for landlords, hold special events for landlords, explaining what's happening with that attachment, right? Internal or interagency survivor councils or peer support networks, offer assistance in in court behavior, provide support trainings, teaching tips about how to testify, how to remain calm in the face of an individual from whom you have suffered, right? What kind of language to use or not use. Next slide, please. And cultural competence. The basics for our DV situations, right? And the basics for virtually any interaction with our clients in the continuum of care is to demonstrate empowerment, to be trauma informed, right? To be aware of when we might be motivating a response that is trauma related or witnessing a response that is trauma related that doesn't seem to be related to any fact, right? But recognizing behaviors that are trauma related that may often seem to be resistant behaviors, right? Or aggressive behaviors. And understanding housing safety, right? Interactions that honor and respect the understanding of the context of that survivor, right? And again, the new eligibility definitions help to underscore understanding the long-term impacts of domestic violence and abuse rather than just the short-term fleeting impact, right? Be aware of and skilled in recognizing and responding to the survivor's culture. So, for example, Native American culture has suffered for decades under the, I'm just going to call it white empowerment, forgive me for saying it in that way, but under white empowerment, at the hands of individuals. They may not trust that to provide information to us. They may not trust that we're going to follow through with what we want. They may not trust that if they provide information that we won't then attack, right? Next slide, please. So in being culturally competent or developing cultural competence, we want to strive to not re-traumatize individuals and persons and households by avoiding an authoritative role or power dynamic. And we've already said that's going to be tricky because the fact that you have resources and access and get to make some decisions about eligibility automatically embeds a power dynamic. You need to avoid requiring retelling of the details in order to get services. One of the reasons that we have that declaration form that can stand alone, recognizing the secondary impact of hearing the realities of survivors' lives time and time again, or day in and day out, and the impact that that has on you and the automatic subliminal trauma that may be proposing to you, right? And that retelling stories may include vicarious excitement and also include stress at the same time. So participants or even staff might find it exciting and exhilarating and energizing to talk about what happened in this case and, oh, can you believe this, blah, blah, blah. But it also induces stress, right? And can violate the person's, the individual's, the household's confidentiality. Next slide, please. So the US culture itself, I apologize, but this is documented through research. The US culture itself can be aggressive and desensitizing against violence. So for example, have you heard phrases like, oh, just shoot me an email. Just give me the bullet points, right? This is on target. This will trigger something, right? That's all language that may traumatize or remind an individual of an incident. It's also language that desensitizes what that's saying in terms of levels of violence, right? Our middle class emphasis on individualism is prominent in our culture, but historic gender, some other historic gender cultures like let's say the Berdache for Native Americans may emphasize community, right? Or South African community will ask you about, rather than jumping right into business, they'll ask you about, so how are your cows? They'll ask you about your cows before they ask you about your wife, right? And those are looking at the communal aspect of, because cows quite often provide for more than the household, right? We use isolation as a nonviolent punishment, like time out in another room, for example, but denies that that is a negative association with being bad or taking bad behavior, behaving poorly, and being denied human contact. So if you're going to use timeout, the recommendation would be timeout where you can observe, right? Quite a tricky parenting skill. So racial, ethnic, and intergenerational differences, what's perceived as normal in terms of aggression or violence. So you might have a culture that yells and screams and, you know, gets in each other's face and tells them about themselves, and that's normal and not perceived as aggressive by the individuals, right? Understand the interaction of the history of trauma in the context of Maslow's hierarchy of human needs, right? So you fulfill the basic needs. The second layer is that sense of safety, right? And if you don't have a sense of safety, then actualizing the rest of the hierarchy is going to be more challenging, right? Recognize the relationship between cognitive, emotional, and brain functions. We call this the think, act, feel relationship, right? And that what happens in the brain controls the ability to act when it's been, when the level of threat is perceived as danger, right? And so there's some automatic things there. We have trainings for both of those. And remember that the caregiver also has these influences happening within them, right? Is that they may also have some of their own traumatic relationships, even if it's not domestic violence, is the trauma of needing to move a country, or the trauma of being a second generation, right? Or the first generation of culture in your neighborhood might be an example, right? Recognize that action absorbs anxiety, so that when you've got someone who's pacing around the room, trying to get them to sit down and be quiet is probably not the best activity, right? Speaking to them calmly, recognizing that they're pacing may be appropriate responses, but saying, please sit down, if you just allow the action, their anxiety is going to increase, right? Adverse childhood experiences, ACEs, we know that ACEs impact the physiological, the physical, the social capacity in later years, and also has some very long-term impacts, not only in teens with related to depression, but also as adults. Next slide, please. So in summary, we've really taken a look at primarily looking at regulations over time. We've looked at the HUD regulations briefly, requirements briefly, and we can delve back into those if you'd like. We have HUD resources and forms available to you. We provided a brief introduction of some of the considerations for implementation and touched on going beyond the minimum requirements of VAWA, right? There's also, in-depth sessions and training for implementation or cultural competency. And we can touch on some of those. We have plenty of time left today, it looks like. Next slide, please. So these are some of the VAWA forms, how to link to them. Again, if you discover that one of the links is not functioning currently, it may be in for language updates. Next slide, please. And then there are the VAWA website, which is partially functioning. It was gone for a while, but is partially functioning, and HUD regulations, which again, we anticipate seeing some new revisions in these areas. There's a series of links there that you can see that provide information about the notices, the original notices, the FEO notices. So if you're a policy wonk and you want to delve into what exactly these say, there's some pieces. Next slide, please. And then there's a whole series of trainings that are from 2022 and 2023 that look at, for example, CDBG. So you may have community development block grant matching to your programs in the COC, right? You may have fair housing concerns, or how to determine how to interact with fair housing, right? So training academies are there for VAWA, right? How to identify impacted by persons of violence when they don't come right in and say, well, I'm here because of domestic violence, or I'm here because thus and so is forcing me to do X and Y. Is that recognizing how the behaviors of persons who are impacted by violence or impacted by stalking can be an important assessment tool for your staff and your community. Next slide, please. I think. So here are more regulations, more public and Indian housing guidance, right? So for Section 8, for example, the notice of proposed information collection with respect to violence, right? And VAWA impacts change the code of conduct elements, again, for any administrative requirements that you're going to see linked here. So when you see that the long administrative requirement, how to function with, how to conduct business with the federal government administrative rule, you'll notice that it does have an update in October of 2023. Next slide, please. And here are some additional VAWA resources that are not necessarily HUD resources. It does have FHEO documents available to you there. And it does provide the Congressional House bill and the trailers of what's happening there. Next slide, please. And I think that is the end. So we have plenty of time for questions or comments or case examples if you'd like. Gershom, I'll turn it back to you and let you help us from here.
Thank you, Pat. And thank you for providing this topic for today. I know that it's certainly not a easy topic to cover, but nonetheless, it is extremely important that our providers receive this training. And so, I would just like to open it up for any questions that any of our participants may have. Feel free to use the raise hand feature, and we would just go by order. If not, feel free to also type your question in the chat, and as I mentioned earlier, we will do our best to answer all of the questions that you folks may have. And then just as a reminder, we will be sharing these forms onto our Google Drive, and I'll go ahead and drop the link in the chat. So all the forms will be uploaded at the end of this webinar, and just as a reminder as well as our recording will also be uploaded onto our website. So again, I would just like to open it up for any questions that anyone may have.
I'm also really open to feedback, like you talked really fast, you didn't give us what we expected or needed, or you need to change your slides. I mean, help yourself to providing feedback to me to be able to enrich the presentation for the future. I have a thick skin and I will not take it personally.
I thought that the training was incredibly helpful and informative. I wish that I had a constructive criticism to provide you with, but I don't. I found it very helpful, and I'm grateful for your time.
Since we had more time today, is there any area that any of you would have liked to us have delved deeper in, or best practices that you would have liked us to share?
Well, Pat, I'm sorry, I don't have something like that, but I actually have a question. And it's in regard to VAWA. So, what if you have a situation where, someone does claim VAWA, you start the VAWA process and you begin doing housing search for the individual, but the individual is just denying a lot of units, and they have a bad background, but we're offering the person, like a unit a month, but do they kind of look at things like that, like the notes, and like they at least see us trying to offer these different units to get this person out of there?
Yes, and I think I didn't put a couple of slides in this presentation that I typically do, is that, your obligation is to make sure that you're providing the first available opportunities, right, to the individual, and that they get to determine what's safe and what's not safe. And so if they determine that this is not acceptable to me, this doesn't feel safe to me, and you continue to provide or offer the first available units, and that you're working with, let's say, ESG and other entities to provide even units that are not permanent housing. So let's say you have someone who's eligible for permanent housing or has been in permanent housing and is saying, no, I'm not comfortable here. No, I don't want that. You can indeed offer a different type of housing assistance if they would accept it. So you could offer rapid rehousing, you could offer transitional housing if you have it, or joint housing if you have it in your community. So the VAWA regulations allow you to work with the participant to find the quickest access to housing that feels safe to them. And so, yes, is that if your attempt to comply is by continually empowering the individual, and that they're saying no, 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 you've complied. So the continuum and your system is not going to say it's not going to be penalized for that. Trying to think through what it is that the client is looking for is one of the case management challenges that you'll have, right? And it may be that they're exerting their element of control that they feel is that how home is where danger is, right? And I'm going to keep saying no because I don't feel comfortable. So helping them walk through what, um, what, what would be comfortable is important. And I said what would be comfortable, and I hesitated there because we don't want to ask them why isn't it comfortable, right? We want to ask them what would be comfortable. Does that make
Perfect.
sense? Because if we ask them what isn't, it may um, reinforce a power dynamic that you don't want.
Perfect. Thank you so much, Pat. And Pat, just a follow-up question, and this is a little different kind of speculation. I was just kind of wondering, looking at the slides. So what if you have an individual where, so let's just say part of our policy is that, we wouldn't move an individual if they're non-compliant. So let's just say they have a guest and they're living in there, and they don't pay their rent, for example. So what if we have an individual that is claiming VAWA, but we do have that policy? So would VAWA kind of supersede that policy where we would need to? Okay, perfect.
Yes, you cannot deny them staying in their unit. You cannot deny their assistance. You could, if they're in a tenant-based rental assistance program like rapid rehousing, you could offer an alternate location, but you can't deny their assistance, right, for that reason, particularly if it's related to the VAWA behavior. So let's say that they didn't pay their rent because the former economic abuse has severed their access or changed their access to other kinds of supports. And so as a result of that, control of their banking, their control of their assets, um, it resulted in not having enough funds. Then that is clearly a situation where you cannot evict, right? If it's directly related there. Now, if it is not related, there is some provisions and some processes to take to offer alternate housing that doesn't have to be in that unit. So does that make sense? And there's some pieces for that. I also see the question in the chat about the VAWA versus HMIS enrollments, is that there's a whole protocol, a whole decision-making tree in terms of what information goes where. And so it is that, and I'll make sure you all have it, but if you have a victim service provider organization that their primary purpose is to work with victims, right? And or the majority of their services are related to victims, then those entities are supposed to put their projects, more than one, into the alternate database for domestic violence, right? However, the protocol, the decision tree, will tell you if it's this kind of program and this kind of program, all of that organization's programs go into the alternate database. But if it's this kind of program and this kind of program, only those programs go into the alternate database, and the rest of the agency's projects go into the HMIS. So you may have individuals, right, who are being served by an organization that has various kinds of programs, and where their data is to reside is based on this decision tree. So I will send it to you because it's pretty complicated in terms, well, actually, it outlines pretty easily, but it does reference some other program numbers that I don't remember off the top of my head, but we'll make sure that you receive that.
Perfect. Thank you, Pat. Are there any other questions from our attendees?
So I apologize for having you block off more time than you needed this morning. However, I've learned, and I will correct that in the future. And I think you get to have some time to think about and decide what you want to do with that time, right? So
Definitely. Well, thanks, Pat. Thank you once again for taking the time to facilitate today's webinar. We truly appreciate it. And yeah, once again, if anyone has any questions, feel free to follow up with us at our email that is on our screen. But other than that, we do look forward to seeing you all in attendance for our next webinar, which is scheduled to take place on Wednesday, April 2nd at 10 a.m. So once again, thank you, everyone, and we will give you the rest of your time back. Thank you.
thank you.